I'm Ricardo Nunez, he, him pronouns. I've been working at the Law Center for over 12 years now. And for anybody who doesn't know, we exist to bridge the gap in legal expertise needed to transition from destructive economic systems to innovative cooperative alternatives. So we're going to be talking about the legal history of whiteness, elimination of bias, implicit bias, etc. And hope that this is useful for y'all within your own organizations, the way that you move through your work, and for the legal professionals here who are wanting to get that elimination of bias credit, that it helps you understand bias in a more structured way, in a way that also acknowledges that it's not just on us and this implicit bias inside of us, but that it's structured at multiple levels and that we can find interventions in all of those different ways. So, yes, what are we here for? We're here for a legal history of whiteness. This presentation was originally created by our former intern, Tracy Bindle. So thank you, Tracy. And then also other parts from Janelle Orsi, our co-founder, and some from Tia and I that we've incorporated in here over the years. As we've done our own internal work at the Law Center when it comes to bias and implicit bias, explicit bias, etc. So I hope you enjoy that photo. I just found it funny. If you want, feel free to drop into the chat your name, pronouns if you like, what brought you here today, and how your body is feeling. So I know I'm feeling a little nervous right now. It's the start of a presentation. So that's how I'm feeling little butterflies a little bit. So what are we gonna do during this presentation? Um, oh yes, and before I keep going, Erica, my amazing coworker and friend, is here as our tech support. So if you have any questions, feel free to DM her. So what are we going to do in this presentation today? We are going to cover the requisite amount of content to meet the elimination of bias requirements. We are also going to discuss how severely fucked up and complicit the US legal system is in the creation and perpetuation of white supremacy in the United States. And we're also going to share some frameworks of how to understand white supremacy culture in the legal profession, in our workplaces, in our lives, and some pathways towards liberation. What we might do is we might have some conversations about the resources we're providing. Because of the webinar format, the way that we're going to mostly be interacting with you today is via chat. So feel free to drop in questions or things, and we'll try to slow down to capture those or to respond. So that's one thing we might do. Another thing we might do is talk about our lived experiences of white supremacy. We might get your feedback and hear what you liked about this training. And we also might get through everything. I know that I tend to put too many things into my presentations, so that's just a warning. What we're not going to do is solve white supremacy today, nor dismantle all systems of oppression, and we're also not going to go into breakout rooms. So those are some things that we're not going to do. Um, Also, we're not racist, D and I. Some of our favorite people are white. um,
That's right. That's my husband and my daughter, my half-white daughter on top. And
yeah,
Luigi
and
Mangione, that one was mine.
yeah, and some of our coworkers here, and also my partner Kitsia and my and her daughter and my niece also in that photo. So, and then I put in this last little thing. Everyone's a little bit racist, and we're gonna learn why. That's part of the reason why we're here to get today is to uncover how we might be perpetuating these systems and how we're impacted by all of these systems of oppression. So, Tia?
Yes. So the elimination of bias credit. If you're here trying to get California MCLE credit, you'll know that you need at least 2 credit hours of dealing with the recognition and elimination of bias in the legal profession and society by reason of, but not limited to, sex, color, race, religion, ancestry, national origin, physical disability, age, or sexual orientation. And then 1 hour of that, of those 2 hours, needs to focus on implicit bias and the promotion of bias reducing strategies, some of which we'll cover later, and to address how unintended biases regarding race, ethnicity, gender identity, sexual orientation, socioeconomic status, or other characteristics undermine confidence in the legal system. So that's why you're here. You're getting specialty credit, and we're happy to provide that for you. Ricardo.
Thanks, Tia. So bias. There's a few different ways, and this is one of the requirements from the California Code, Legislative Code, on completing these MCLE elimination of bias credits is explaining the difference between implicit, explicit, and systemic. So implicit bias is the attitude or internalized stereotypes that unconsciously affect our perceptions, actions, and decisions. These unconscious biases often affect behavior that leads to unequal treatment of people based on race, ethnicity, gender identity, sexual orientation, disability, age, health status, and other characteristics. So no one is immune from the harmful effects of implicit bias. Implicit or unconscious bias is just that. It's like it's below the surface level. And when I think of it, and when I was thinking of it, La La Land kind of came to mind. It's like when we're on autopilot and just kind of like frolicking about or going about our day without recognizing how these biases are showing up. Explicit or conscious bias is that some person is very clear about their feelings and attitudes, and related behaviors are conducted with intent. So the type of bias is processed kind of neurologically at the conscious level. It's declarative. It can happen in words and behavior, and can be expressed through physical and verbal harassment or through more subtle means such as exclusion. So, or another way of just saying this in the context of today's training is that's racist. So, this image coming from a beautiful show called Wonder Chosen from years ago. So, dating myself. The last is systemic bias. So, this is the inherent tendency of a process to support particular outcomes in human systems, such as institutions. And it includes institutional, systemic, and structural bias, which can lead to institutional racism, which is a type of racism that is integrated into the laws, norms, and regulations of a society or an establishment. And this photo is an image of redlining and how state policy was enacted and created to basically disenfranchise and under-resourced particular communities, and in this case, African American communities. So in other words, it's when we design policies and practices that disproportionately benefit white people and exclude and harm people of color, and then use the negative, and then a lot of times the implicit bias happens when we use those negative outcomes from the policies as evidence for ourselves unconsciously of racial superiority and inferiority. So, and what I want us to try to do in this training is allow us to figure out ways to lead to meaningful change. So I hope it's an exploration of implicit bias that's situated in a much larger conversation about how current inequities in our institutions came to be, how they're held in place, and what our role as participants in our communities and our organizations and the legal profession is perpetuating inequities despite our good intentions. So, yeah, so how do we situate ourselves and the healing work that we need to do within a broader structural context of the legal profession and the laws of the United States themselves? And when I think about dismantling implicit, let alone explicit and systemic and structural bias and systems of oppression, I think of it as a process. When in particular, the ability of harmful associations and assumptions about people of color that endures is a fact that we've come to accept the structural and institutional inequities we have created as normal. It's just how it is. It's the water that we're swimming in. And so I think we've all, over the last few years or decades, depending on our own journey, we've all recognized the water that we're swimming in. And so these moments can be difficult and challenging. And so I hope that today's webinar can help make it a little bit less challenging. And just from me, like one of my formative experiences as it relates to implicit bias and white supremacy came about when I was living in Zambia. When I was living there, many of the myths that I had internalized through my life about whiteness, blackness, and the dynamic structures and policies that perpetuated white supremacy, colonialism, patriarchy, and so much more started to unravel. This is a photo of when we would do an event called Cinco de Mayo, which is all the Peace. I was in Peace Corps, and Peace Corps volunteers would come together and we'd make Mexican food for on Cinco de Mayo. And women there, their honorific name was Bamayo, or mother. And so we would invite the Bamayos of the village to come and eat with us, and then we would do different activities. So this is my little brother there hitting the piñata. So also, my father's side of my family is from Mexico. My paternal grandfather was Purepecha, the ethnic and tribal group whose empire makes up what is today most of the state of Michoacan. And living here in Michoacan, again, I'm experiencing that unraveling of internalized biases I had of Mexicans and I had of myself. And so when I look to frameworks like this resist and build framework, I see it as intentionally integrating ancient wisdoms and practices brought forward to help us heal from undemocratic, alienating, and frankly, sociopathic values embedded in our institutions and systems. I don't want us to think that we're trying to police your thoughts. Actually, we're abolitionists, so why would we want more police like in your head? What I was reminded about recently by Lindsay Gibson, who wrote the book Adult Children of Emotionally Immature Parents, you should read it, is the fact that having a thought or feeling isn't initially under our control. You don't plan to think or feel things, you just do. Your thoughts and feelings are an organic part of nature expressing itself through you. Nature isn't going to be dishonest about how you feel, and you don't have a choice about what thoughts nature brings up in you. So accepting the truth of your feelings and thoughts doesn't make you a bad person. It makes you a whole person and mature enough to know your own mind. And so what we're trying to do, I think, here as well, is to get us to understand the biases as they come up in our minds, so that we can be aware of them and understand these thoughts and feelings and find ways to be compassionate with ourselves so we can dismantle the bias that has been socialized into each of us. So what's whiteness? I put some photos up here from an author, Christian Lander, who this is his words, has studied white people for years and wrote a book about the unique tastes of white people. So I'll go on. Well, he says white people don't like stuff that's easy to acquire, and beer is no exception. Microbreweries, as an example, or white people often say they are spiritual but not religious, which usually means that they will believe any religion that doesn't involve Jesus. So it's a funny way of entering this conversation, because so much of it is actually really heavy and difficult and challenging. But before I pass it over to Tia, just really quick, like when we're talking about whiteness and the creation of whiteness, how should we understand it when it comes to race and racism? So race is not a natural or a biological category. It was made up. Race can be defined as a specious classification of human beings created during a period of worldwide colonial expansion by Europeans using themselves as a model for humanity for the purpose of assigning and maintaining white skin access to power and privilege. So racism is defined as social and institutional power combined with race prejudice. It is a system of advantage for those considered white and of oppression for those who are not considered white. It is a white supremacy system supported by an all-class collaboration called white, created to end cross-racial labor solidarity. And so when we look at white supremacy, and a definition just to give it, is the idea or ideology that white people and the ideas, thoughts, beliefs, and actions of white people are superior to people of color and their ideas, thoughts, beliefs, and actions. So in the United States, whiteness is the dominant and privileged identity, socially constructed to justify conquest and slavery and reified in laws and policies, both historic and current, that ensure that white people benefit disproportionately from the benefits of society and protected from more of its harms. As such, what is deemed as good and acceptable is normed to white people. And we have all, white people and people of color, internalized an anti-Black and brown bias. And there's another framework before I pass it over to Tia, as whiteness as property and understanding what whiteness is. This was developed by Cheryl Harris. And the concept posits that whiteness has historically conferred legally protected rights, benefits, and status. Whiteness, therefore, has been valued, provides tangible and intangible benefits like status and wealth, and is expected to maintain this privileged position within law and society, even as segregation ended. And this property interest in whiteness shapes legal expectations and maintains systemic advantages, though this value is a socially constructed phenomenon, obviously, rather than an inherent quality. So to see how true this is, I'm going to pass it over to my coworker, Tia, so she can tell us a bit about the legal history of whiteness in the United States. Tia?
I said, thank you, Ricardo, for that intro. All right, let's get into the legal history of whiteness. So, there are three ways that whiteness has mostly been legally defined. One is to create a group of people that are exempt from laws that restrict Black, Native, and other races. The second one is in the context of immigration laws and keeping people out of the United States. And the third one is by census categories. Ricardo, I saw that you were going to try to say something.
Oh, just for a moment, I didn't see your screen, but I think that was just me. Sorry.
Okay, no worries. So let's start with the first one, where the definition of whiteness is about creating a group of people that are exempt from restrictions. So first, one of the first times we legally started differentiating the treatment of whites from others is with the case of John Punch. So in 1640, a guy named Hugh Gwynn had three indentured servants. One was a Dutchman, one was a Scotsman, and one was Black. When the three indentured servants ran away and were caught, their punishments were different. The white guys, the Dutchman and the Scotsman, got 4 extra years of indentured servitude. But then the court said that because John Punch was Black, his punishment was to be a servant for the rest of his life. So John Punch became the first person legally enslaved under criminal law in the English colony of Virginia. And of course, that's the first of many. And this was in 1640, about 20 years after the first Africans were kidnapped and brought to the colonies. Then in 1662, Virginia enacted a law of hereditary slavery, meaning that a child born to an enslaved mother inherits her slave status, even if the father is an Englishman. So, in other words, by law, even if you're half white, you're not white. And then in 1670, the state of Virginia prohibits free Black people and Indians from keeping Christian servants. And by Christian, they mean white. But also, they made sure to say that converting to Christianity doesn't free you from bondage if you're not white. So, in other words, Christian means white, but also Christian doesn't mean white. And I'm sorry that this isn't going to give you clarity on the legal definition of whiteness. I'm just showing you the legal history. Okay, in 1680, there was a debate about the definition of whiteness, again in Virginia. The governing body asked, "What is a white man?" And the definition they came up with was a white man, a quote, a white man is one with no Negro or Indian blood, with the exception of the descendants of John Rolfe and Pocahontas. And that's called the Pocahontas exception. And a note about Pocahontas, her real name was Amunute. And back in 1616, before this debate was happening, she married John Rolfe. There was a huge scandal in the English court, and it wasn't about race because they weren't so preoccupied with race yet. The English Protestants' enemies were Spanish Catholics, and the Native Americans had different languages and customs from each other and weren't a monolith, and obviously didn't see themselves as a united group against the English Protestants. So really, the scandal was just that this princess married a commoner, John Rolfe, but also Amunute wasn't actually a princess. The English just didn't understand or care to learn about Powhatan hierarchies. But anyway, their descendants are white because of this Pocahontas exception. And then after all this, the government became really preoccupied with race. So here's a survey of all of these laws, not all of these, some of the laws of many, many that are restrictions on Black people and Indians. So in 1703, Rhode Island makes it illegal for Blacks and Indians to walk at night without passes. Similarly, in 1710, New York forbids Black people, Indians, and mulattoes from walking at night without lighted lanterns. In 1819, Virginia outlaws Blacks and mulattoes, whether free or enslaved, from meeting for the purposes of education and forbids teaching Blacks to read and write. In 1806, Ohio enters the Union as a free state, but passes anti-Black laws in 1807, requiring Black people who want to move to Ohio to prove that they were not slaves and to find at least two people who would guarantee a surety of $500 for their good behavior. In 1850, in California, we passed an act regulating criminal proceedings, barring Blacks, mulattoes, and Indians from testifying for or against a white man. The act also defines mulatto as having 1/8 part or more of Negro blood and defines Indian as having 1/2 of Indian blood. Note not only the difference in ratios, but also the definition of Indian doesn't include 1/2 or more of Indian blood, just 1/2. So if you're 2/3 Indian, maybe you're not Indian, because that is white people math. And then in 1854, this guy named George Hall was a white man. He was convicted of murdering a Chinese miner in Nevada County in California. And the conviction was based on the testimony of Chinese witnesses. So George Hall appealed his conviction, arguing that the law that we just talked about, barring Blacks, mulattoes, and Indians from testifying against white people, he argued that this should be extended to prohibiting the Chinese from testifying too. The California Supreme Court sided with George Hall and even said the Chinese are inferior and have different language, opinions, color, and physical conformation. And so therefore they shouldn't be able to testify against white people. In 1863, the 13th Amendment is adopted, supposedly abolishing slavery, except for people who have been convicted of a crime. And of course, this leads to the rise of Black codes that creates a lot of crimes, thereby allowing Black people to still be enslaved. One example is in 1890 when the Louisiana government enacted the Separate Car Act, requiring railway cars to create separate cars for white people and separate cars for Black people. And this leads to the case Plessy v. Ferguson. Plessy was 1/8 Black. He was white passing because he was 7/8 white. But legally, he was still Black because he doesn't fall under the Pocahontas exception. He joined a civil rights group called the Citizens Committee of New Orleans, and they recruited him to deliberately violate this act that Black people couldn't sit with white people. The way they did it, they were so organized, they gave the railway company notice so that they could show a clear intent to violate the act. And then the railway company cooperated because it was expensive for them to have one car for whites and one car for blacks. And so then they got a private detective with arresting powers to arrest Plessy when he sat in the white car. And when he was arrested, his lawyers argued that this act was in violation of the 13th and 14th Amendment. The Supreme Court says the act was constitutional because even though the 14th Amendment intended to establish absolute equality for the races before the law, separate treatment did not imply inferiority of African Americans. And Justice Brown goes as far as to say that the cars reserved for white people and the cars reserved for black people were of the same quality, so they were separate but equal. And this doctrine remained valid until 1954 when it was overturned by the case Brown v. Board of Education. And that's how whiteness was defined as privileges for a group of people who can bypass certain laws. All right. Another way to define whiteness is by looking at our immigration laws. So before the Naturalization Act, we had two ways of becoming a US citizen. One is by being born in the United States, that's called right to the soil. And the other is by bloodline, which means your relationship to your parents and your ancestors. If they are US citizens, so are you. And then there's the Naturalization Acts, which say who can become a US citizen if they don't have birthright citizenship or citizenship by blood. Let's start with Wong Kim Ark, who had two parents who were Chinese citizens, but they had him here and he was born in the United States. He goes to visit China in the 1890s. He comes back, but because of the Chinese Exclusion Act, which says people of Chinese descent can't immigrate to the US and also cannot naturalize, the Border Patrol denied him entry. And he said, but I'm a US citizen. I was born here. And the US Supreme Court says that because of the 14th Amendment, if you were born in the US, you are a US citizen. So he was able to stay. So this is one happy story I'm going to share. Okay. But if you aren't born in the United States, you have to go through a lot of hoops to become a citizen. And the Naturalization Act of 1790 established the first rules for granting US citizenship to foreign-born individuals. It primarily allowed free white persons who had resided in the US for at least 2 years to become citizens. And then the Naturalization Act of 1870 extended citizen eligibility to all aliens of African descent while denying the right to all other groups of non-whites, particularly Asians. And this is where the Supreme Court begins to decide many, many, many cases of whether someone is white, because you have to be white to become a citizen. Let's start with the case of John Svan. He was a Swedish Finn in 1908 in Minnesota. He and 15 other Swedish Finns were denied citizenship on the grounds that they were Mongolian. The court threw this out 2 weeks later, saying, although Finns had been racially mixed because of years and years of interbreeding, Finns have actually become one of the whitest people in Europe. So first, Swedish Finns were not white, and then 2 weeks later, they were some of the whitest. And in Dow v. United States in 1915, George Dow came from Syria and applied for citizenship. The Court of Appeals affirmed George Dow's right to naturalization. They said because he's from Syria, he's Caucasian, and therefore he's white. But some courts later then claimed that only Syrians and not other Arab people were white. And then in 1944, the federal government deemed all Arabs and Northern Africans to be white. And back to 1922, Takao Ozawa applied for citizenship. He was Japanese. Was he white? He tried to claim that he was a free white person because under some definitions, you're white if you have no Negro or Indian blood, and he was neither of those. And in a unanimous US Supreme Court decision, Japanese Americans are not eligible for citizenship because the words white person were meant to indicate only a person of what is popularly known as the Caucasian race. So now we're talking about Caucasians again. And what is a Caucasian? Anthropologically, Indians from Asia were Caucasian. A man named Bhagat Singh Thind applied to naturalize. He said, I'm a free white person because I'm a high caste Hindu with full Indian blood. And was he white? Well, the Supreme Court says he's not white because while all whites are Caucasians, not all Caucasians are white. So they have to again explain themselves. And the great legal minds of the US Supreme Court comes up with this definition. A white man is who the common white man recognizes as a white man. So that is the definition for immigration purposes. Now, with the census categories, this is the third way of defining whiteness. And let's start with, to illustrate, the official racial status of Mexican Americans. The Census Bureau between 1850 and 1920 considered Mexican Americans white. And then in 1930, Census Bureau employees were instructed to write MEX, Mex for Mexican, and W for white, thus creating a distinction between them. So they're not white. Then in 1940 to 1950, they're white again. And the workers are instructed to write W for both Mexicans and whites, unless if the Mexican is of full indigenous descent. So yes, unless no. And then in the 2020 census, most recently, um, it just says Hispanic origins are not races. And they ask you to list if you are of Hispanic origin and then ask your race. So that's Mexican Americans now. And then, and in 1977, the government finally defines racial and ethnic categories. The Federal Office of Management and Budget issued Directive 15 to create standard government race and ethnic categories for the first time. And of course, they're arbitrary and inconsistent. For example, Black is a racial group and white wasn't. American Indians were required to culturally identify as American Indian, and they have to do that with some affiliation with a tribe, while white people weren't required to do that, even though their definition in the Census Bureau was a person having origin in any of the original peoples of Europe, the Middle East, or North Africa. But they didn't have to identify which one. It doesn't matter. But in 2020, the census now asks whites to mark X for the race box and then to print their origins. For example, it says German, Irish, English, Italian, Lebanese, Egyptian. And then it also lists Chinese, Filipino, Asian, Indian, etc. ethnicities, but not under the race Asian. They're just listed there. So that is just another inconsistency. And that's whiteness. That is the three ways that whiteness is defined legally. All right, but today, the census today. So the primary purpose of the census, even though this is how I use it a lot, it isn't to help us gather demographic information. If you paid attention in your government class, it's actually used to determine how presidents and members of Congress are elected. The 14th Amendment requires the whole number of persons in each state to be counted. In other words, every person has to be counted. But earlier this month, Trump said he wanted a new US Census to exclude counting undocumented immigrants. And this move was recommended by Thomas Hofeller, who's dead, but good riddance. And he's a Republican redistricting strategist. He said pushing to get a citizenship question on forms for the 2020 census would be advantageous to Republicans and non-Hispanic whites. So to this day, we are still, making legal decisions based on how to advantage white people. Luckily, the decision to do this doesn't the president isn't empowered to decide whether or not to count undocumented immigrants, and this has gone to the court, and they're still trying to figure it out. And now, also, white people are victims of discrimination. If you've heard of the Students for Fair Admissions, they're this very busy anti-civil rights group, and they sued Harvard and the University of North Carolina, UNC. In 2023, the Supreme Court held that Harvard's and UNC's race-conscious admissions programs violated the Equal Protection Clause of the 14th Amendment and the Civil Rights Act. The court held that race-conscious programs must not use race as a negative. And they found that Harvard's and UNC's programs failed to meet this requirement because their programs allowed for a tip or a plus to be given to an applicant based on their race alone. So, according to the court, using race in this matter inherently allows for the negative use of race because of the zero-sum environment of admissions. A benefit provided to some applicants, but not to others, necessarily advantages the former group at the expense of the latter. So they said, you can't do that anymore. They also ruled that race-conscious admissions programs must not use race in a way that reinforces racial stereotypes. And they said these colleges did not meet this factor because their programs provided preferences to students on the basis of race alone. So this resulted in a system that rests on the quote, pernicious stereotype that a Black student can usually bring something that a white person cannot offer, which is impermissible. And this picture of a white guy holding a sign that says, I am Asian American, I have a dream too. He's the lead counsel for these cases, and he's very, very proud. But if, we've been dealing with a lot of um, we've been learning about restorative practices at the Law Center, and part of that is trying to give people grace where you see ill intent and evil. They might have like good stuff inside them. So I tried to do that for this guy. And, I think the argument is just that they want college admissions to be fair. They want everyone to be um, assessed equally based on objective standards. And so knowing that someone is Black or Hispanic should not make it such that they get into Harvard over somebody else. Okay, so that's assuming many things. That view assumes many things, and I'm going to challenge that assumption with the next slide about the Nextian experiment. This was an experiment that was done in 2014. It's old, but there isn't a newer one. But so basically, these consultants took 60 partners from 22 law firms. And by the way, according to the ABA, only 28% of partners are women at law firms in the United States. So that's why there's only 16 women on this graph. And then same thing, 5% Asian, 3% Hispanic, and 2.5% Black. So my graph is accurate, like it reflects what partners look like. But in this study, back to the study, all of these partners were given an identical memo, supposedly written by a Thomas Meyer. Half of the partners were told that Thomas Meyer is white. The other half were told that he is Black. And they were all given the same exact memo containing the same exact spelling errors, spelling and grammar errors. There were 7. But the partners who thought Thomas Meyer was was white, only found 3 of those errors. And the partners that thought Thomas Meyer is Black found 6 out of 7 of those errors. The partners who thought he was white rated his memo 4.1 out of 5 stars. And the Black Thomas Meyer only got 3.2 out of 5. So these are 60 partners assessing the same exact memo, and the only thing they knew to be different was the race of the fake author. So what does this say about whiteness in the legal profession? This experiment only covers one memo. Imagine a lifetime of being scrutinized and graded more harshly. Why shouldn't a Black student with a 4.0 GPA get a plus when graders will find more errors in their work, even if it has the same amount of errors as a white student's? Simply put, Black people and lawyers get scrutinized more, and we can't escape prejudice when scanning for these so-called objective criteria, like spelling errors. And I'm going to pass it over to Ricardo to, let's see what you're going to talk about. Oh, how the legal profession perpetuates white supremacy.
Thanks, Tia. Appreciate it. Um, Before we continue, I'm just going to invite us all to take a deep breath. Now, I know, like, listening to those little snippets and pieces of our history, and particularly the legal history, can land in different ways for myself, and that can be challenging and painful, make me angry, make me sad. So just wanted to give us a second, yeah, to acknowledge that. Yeah, and as I'm getting my slides ready, feel free to drop into the chat questions or reflections about what's been shared. Thanks, Elizabeth, for dropping in how I forget the exact how crazy all of that history is that Tia was covering. So yeah, feel free to do that. But okay, so part of the implicit bias training is to talk about ways out of and acknowledging implicit bias. And so when we're looking at the legal profession and the history that we just learned, the question then comes up, are lawyers just another pillar of an oppressive and extractive system where white supremacists have created and rigged rules to facilitate their own accumulation of wealth and power through theft, dehumanization, and exploitation of Black and brown bodies and labor? And what and if we're all attorneys and legal professionals and in this field, or at least some of us, is there another path? What could we offer, or what could we do? What's the different path for people who make their livelihoods working in and with law? So in the same way that restorative or transformative justice models have helped people embrace prison abolition, can we offer a new vision of legal work that can eventually replace the current bar-controlled model? So, Erica, thanks for putting in the chat that in Brazil, Japanese people were determined to be white, and that's why there was so much immigration of Japanese people to Brazil. So thanks for sharing that. So we have this mess in front of us, and we're trying to figure out something to do with it. And I think part of our work at the Law Center is to find the way forward to take this mess that we've made and create something beautiful together, and to share that with others, to get feedback, and to be in community with others who are trying to do similar work. And this transformation is not a sacrifice. It's a return to each other. We need each other. And so to me, this act of transformation, it can feel heavy at times, but I find that it is incredibly liberating, in recognizing that our greatest wealth is to be found in each other, and that our destinies are intertwined. It reminds me that of the idea that charity is not solidarity. We're not coming to save other people. We are coming because we understand that our fates are intertwined. And so when we are entering the space of how do we combat implicit bias, explicit bias, and structural or systemic bias, that we can think of these things, these interventions, as different levels and different levels of liberation. So we need to recognize that ourselves and our organizations and the legal profession is part of a larger web of systems that perpetuate these existing dynamics. And so what's the legal profession got to do with it? When when the state bar and the legislature says every attorney needs to do 2 hours or 4 hours, I forget, sorry, of specialty MCLE credits on elimination of bias, it feels to me like we're putting Band-Aids on the Titanic. And so we need to figure out other ways to move through this and to get to the roots. And so one of the guiding questions that my coworker Janelle came up with is, does this perpetuate separation and domination, or does this foster connection and nurturance? So when we look at the creation and development of white supremacy and whiteness as property, that is a system that is trying to other certain people and create a space of belonging for only a particular group of people. And when we understand that we need each other, we can actually start to break down these systems of oppression and find the strength and the wealth in each other. So there are parallels between the construction of whiteness and the legal profession, as we've just heard. And we need to actively deconstruct both of those systems. So we've created artificial lines that have caused harm. Race has long been and continues to be a common dividing line of dominance and subordination. It controls how people within this category behave. So white people are, it's not only people of color that are impacted negatively by this system, it's white people themselves. They are put into boxes. And other things that are put into that box are purity, the nuclear family, heterosexuality, the control of women. And so these people are not actually able to live their full selves, and the law helps perpetuate that. Similarly, the work that lawyers and only lawyers are able to do is practice law. And so we've seen this, just the ridiculousness of it when it comes to, is that legal advice or is that legal information? And it's funny, when I've gone in to try to find definitions, it's like the definitions just like don't make a lot of sense when you think about this monopoly over the legal field. And that is created also through the perpetuation of lawyers keeping a claim on the law and constructing boundaries around it that, even though it's slippery, they're really, really trying to maintain. And so we should be suspicious anytime that people are fiercely trying to protect a thing that isn't actually a thing. So whiteness and being a lawyer are things we can have. They're assets, they're strategies to own and control. And so when we think about who controls and owns the legal profession and the law, the profession is predominantly controlled by white people. And even though there is an increasing number of people of color who are becoming lawyers, that proportion actually is not keeping up with the proportion of the US population in general, of the number of people in our communities who are people of color relative to the number of white people. And so when we think about the legal profession and law firms, who owns the law firms? And so at the top 100 firms, 93% of managing partners are men and 92% of equity partners are white. And so disproportionately, even those people of color who are attorneys, who are working in the legal profession, are working underneath disproportionately white and male bosses in those spaces. And so is there something about the law compared to other professions that that make it that perpetuate this level of not being diverse? Yes, lawyers are and is a profession, and they are creating these fake lines, and they've created some of the strongest ones for themselves. For example, well, the law is the least diverse profession in the country, and lawyers aren't really doing anything to change that. When the question comes before lawyers of whether to change the bar exam pass rate or the questions that are asked, typically lawyers who have their bar license say no. And being an attorney who became an attorney through the legal apprenticeship program, the bar is just such this like ritual that is dehumanizing and painful and is not the thing we should be using to as the gatekeeping mechanism for us to becoming attorneys and to allowing people to understand how to access law and the legal profession. And so, like I mentioned before, when attorneys are asked by the state bar to should they increase bar exam passage rates, they said no. So that's just an example of how this thing is being constructed, these boundaries are being constructed to stop people from entering the legal profession. And so it's a question, is it time to end the profession's monopoly on the practice of law and putting attorneys into these boxes and we're the only ones that can do this? And so what attorneys can start to do is to nurture connection, to cross borders, to blur boundaries, and to take some leaps. We can reject power and pay hierarchies. So we've done a lot of work around this. I think one of our earlier workshops was on equitable pay. And we recently did that workshop as an example. We can try to give the law back to the people. A lot of the work that we do at the Law Center is creating resources that are actually accessible by the people who need them the most. We work on transformative models for dismantling structural inequalities. So here's a list of Black, Indigenous, and immigrant land projects that we've been working on. And we can also listen and learn together. So, and it's not only within the legal field that we should be doing this, we should be working with our movement partners, with communities, and understanding how can we make this power that we have, because it is a power, of being legal professionals and put it into the hands of the communities that are looking to transform their lives and their material conditions. And so looking at pillars of regenerative economy from the Just Transition Framework is one example of how we at the Law Center are trying to incorporate the values and perspectives of movement leaders and movement folks into the work that we're doing. We also just want to, or I want to recognize that we as an organization and a lot of attorneys who are working exist within the nonprofit industrial complex, which is a system of relationships between the state, the owning classes, foundations, and the nonprofit NGO social service and social justice organizations that encourages social movements to model themselves after capitalist structures rather than challenge them. And so a lot of these structures are not only capitalist, but in our context, white supremacist. And so how can we work inside of our organizations at that level of liberation and intervention to challenge white supremacy? And so the one resource that I'm sharing right now was created by Aorta. It's a cooperative that does trainings and education on these types of things, like dismantling white supremacy in the workplace. And they use this metaphor of the iceberg. And so what can we see above, the water and what's below it? So looking at above the water, the interpersonal, how is white supremacy manifesting in the interactions happening between people and observable behavior? So tone policing, retaliation, speaking out against racism, competitive wokeness, and then below kind of the water, institutional. How is white supremacy manifesting in the policies and practices of the organization? So what are the pay and benefits looking like? The hiring processes? What's the relationship to the community? And then cultural. How is white supremacy manifesting in the beliefs and moral code that govern the organization? Is overworking the unstated norm? Is there a fear of open conflict? Is there power hoarding? So Aorta is an amazing organization that can provide more resources and tools to support you and your organization in combating anti-Black racism. Other ways is rethinking how we actually do the work that we do when we're working with clients. So how are we actually, what are the processes that we're using as we're moving through client work, both with our clients and also educating them and understanding what these tools are and what are the assumptions. How How are we uniting people, attuning people to what's most important to them, nourishing them as they're moving through this process, creating spaces of learning and adapting through working with a legal professional. So these are all some tools for us to use as we try to combat and dismantle white supremacy. So I'll pass it over to Tia for to share a little bit about our community gatherings and our Community Over Chaos campaign.
Yes, in the last 2 minutes. Wow, we did it. Um, yes, please help us raise $30,000. We need about 7,000 more to raise that. And 10% of what you donate will go to our partners, our solidarity partner, the Let Us Contribute Initiative, or Lucy. They're working to bring cooperatives to life in California prisons. So that would be like worker-owned co-ops in prisons, owned by people in prison or formerly incarcerated people and their allies, I assume. And Lucy is a movement building coalition led by incarcerated and formerly incarcerated people.